reunification cases in Europe and Latin America. And for those that don't know much about family reunification, the definition given by the UNHCR is the process of bringing together families, particularly children and elderly dependents, with previous care providers for the purpose of establishing or re-establishing long-term care. But of course, different countries have different approaches to how family reunification cases are dealt with. And the laws, of course, are different in different countries. So some are more draconian, some are more opaque, and Patricia is going to be exploring that in the course of her presentation, which leads me on very nicely to an introduction to our speaker. Patricia has done a great deal of work in the area of immigration law. Her work is so extensive that I think for time, I probably don't have enough time to list all of it. So if you do want to find out a bit more, then look at the event description, which has a few kind of summary points of Patricia's incredible experience. So I really recommend you to check that out. But without further ado, I am going to hand over to Patricia, who's going to present on the different cases in Europe and Latin America. Over to you, Patricia.
Thank you. Thank you so much for the opportunity of being here, talking to you. I'll be sharing some slides now with my presentation. So I am really glad to be talking today for the Network for Migration Matters about my research on family reunification. So this research on family reunification for refugees, it was based in my PhD. So in my PhD, I studied the Brazilian family reunification policy for refugees in Brazil, but considering a comparative approach with the situation in Europe and also in other countries in Latin America. So today, I will talk a little bit about this research. This is the summary of my talk. So first, we're going to talk about family reunification for refugees in Europe, different definitions of family in Europe, the difference between family reunification in asylum and subsidiary protection, and I will explain what is subsidiary protection. And then we are going to talk about family reunification for refugees in Latin America, so in the Latin American regime for refugees, in the national legislation for asylum in some Latin American countries, and then some thoughts on the Brazilian case and the conclusions. So first, why is family reunification important? So refugees and forced displaced people, they don't plan leaving their countries. They have to because of conflicts and persecutions. And in the case of Latin America, many countries recognize serious and great violations of human rights as a situation to grant the refugee status to a person. So when these people, they go to another country, they have a high probability of being separated from their families. And the only way for them to be together and to have the right to family, there is a right that is recognized by many human rights documents. So the Universal Declaration of Human Rights, the International Covenant on Political and Civil Rights, the European Convention of Human Rights, the Inter-American Court of Human Rights, is if the countries allow these families to be together. And how they do that? Granting visas for the family members to be reunited with the refugee or the other person in the asylum country. So in Europe, one important piece of legislation is the Council Directive of 2003 on the right to family reunification with third nationals. So this directive, they guarantees the right to family reunification to different types of migrants, including refugees. So we have the explicit recognition of a right to family reunification. And we don't have this recognition, for example, in the UN Convention on relating to the refugee status of 1951. So this directive, it gives the minimum ground where the states have to guarantee the family reunification for spouses and minor children. So we see in the European legislation a very narrow definition of family that many times is not the same definition of family that we have in other parts of the world. So although we have a universal idea that family is important and that human beings, they have a right to family and family life, there is no universal definition of what is a family. So in many cultures, the definition of family is broader, and this broader definition of family is important for the care of children, for the survival of the family, because the family members, they will have different roles. So for example, in some cultures, raising children is not a role of just the parents, but is a role of the entire community. So aunts, uncles, grandparents, they are important for raising those children, especially if the parents, they have to work outside the house. So the role, the task of taking care of children is from these extended family members. And especially in Africa, but also here in Latin America, we have extended definitions of families that are more important. So one way to restrain the right to family reunification or make this family reunification procedure harder is if you use a very narrow definition of family. And most European countries, they use this narrow definition of family. The second way to make the family reunification for refugees harder is adopting procedural impediments. So the first one is DNA tests. While some people can argue that using DNA tests is really important to prove that, for example, a man and a child, they are father and son, for example, especially in the context of conflicts and lack of documentation, DNA tests can be a huge impediment for family reunification. First, because many families, they are left behind in refugee camps or in situations of conflict. So accessing the genetic material to do this in transnational DNA tests is really time consuming. And there can be problems with the DNA test, especially in situations with prolonged conflict. So for example, you have a family where there is the wife, the husband, and they have a child, a girl. But let's say this woman, she was raped, but she got pregnant. Nobody can say who is actually the father. Her husband is the father of the girl. They have to move. She become a refugee in, I don't know, in Germany. She wants to bring her husband. They ask for a DNA test with the child. In the DNA test, they say they are not father and daughter. So you are just separating this father and this daughter because they are father and daughter forever. So the problem of DNA tests is that there are chances of mutations that can separate people that are related forever. You are defining family just based on genetical connections, and the definitions of family are much broader than just genetical definitions. They involve cultural, social aspects as well. So the use of DNA tests has to be more discussed in the context of family reunification. And in countries that adopt them, they should be used as a last resource, but this is not the case in many countries, especially in Europe, but also in Canada, Australia, and the United States. There are some waiting times for some categories of forced displaced people. So for example, some resettled refugees in the US, they have to wait 6 years before they can apply to family reunification. And some countries, they're also adopting pre-integration tests, so tests like language tests or material exigencies, including that the refugee has to show that they have some house, that they have salaries that can support the family. And those exigencies, they are really hard to read for refugees that in general, even though they can be qualified, they have a hard time to find better jobs or to get their qualification revalidated and acceptable in the asylum countries. And some countries, they adopt maximum deadlines. That means that the refugee can apply for family reunification 3 years after, for example, they were recognized as refugees. But the problem is that sometimes they can find a family member that was disappeared after this deadline, or they don't know the deadline, or they just can't meet the other requirements to apply for family reunification after this deadline, and they end up permanently separate from their family members. There is also a tendency to deny family reunification for unaccompanied children. And the United Kingdom has been really criticized to make this family reunification with unaccompanied children harder. And some states, they use, they justify this to avoid that the families, they would send the children alone in dangerous journeys. So those children would be used as anchor children for the rest of the family to come. So those countries, they are making harder family reunification for unaccompanied children, justifying the need to protect children from this practice. At the same time, there are a lot of studies that show the benefits of family reunification for refugees. The first one helps refugees with local integration. The refugee will not have to worry if their family members, they are alive, because they will be with their family members, so they could focus in learning the language, in getting a better job. It can also help the refugee to have more social networks. So for example, there are some literature, some cases where when the child arrived, this child start going to the school, the refugee parents, they have to go to the school and to be involved in the school life, and this helps them to create a social network in the asylum country. There is also economic benefits of family reunification with refugees, because when the family member is left behind, the refugee, they have to send remittances sometimes to help the family to survive. And this money, if the family is together, will stay in the country. That is, the refugee can use this money to invest in himself, maybe to open a business, and to move the economy of the host country. So in general, and there are no studies that shows that refugees or family members of refugees who came by family reunification, they use more social services than nationals or other migrants. Another way that some countries, including in Europe, they have been using to make it harder family reunification for refugees is accusing refugees of fake marriages and fake partnerships. But there was a study of the European Migration Network from 2016 that analyzed this misuse of family reunification in general, not just involving refugees, but also involving EU citizens and other migrants in general. And the results is that the number of cases of misuse of family reunification rights are really, really small comparing to the costs of actually investigating all those cases and the risks of violating the right to life and to family unit to investigate those cases. And there were no evidences that refugees or migrants in general, they would be more involved in misuse of family reunification than European citizens, for example. And here in this table, we see how the definition of family is really problematic in different states. So we have the nuclear family as the main definition of family for family reunification purposes in Europe. But some countries, they just accept family relationships that were established before the arrival in the host country. So for example, if you have a situation of a refugee who stayed, I don't know, 10 years in a refugee camp, and then they get married in the refugee camp. Sometimes some countries, they don't accept this as family, and they don't accept a situation, for example, where the refugee had a girlfriend, they decide to get married when the refugee is already a refugee in the host country. They will not recognize this as family relationship. And other countries like Bulgaria, Croatia, they accept family without this time zone. Some countries, they accept parents in the case of unaccompanied minors. Sometimes they accept parents not to violate the right to family life in the European Convention. Some other countries, they do not allow family reunification of parents in case of unaccompanied minors. And even in some cases where parents are accepted, the parents, sometimes they are in a hard situation where they have to choose if they want to be reunited with the unaccompanied minors in the asylum country, or if they want to stay with their other children in their host countries, in the origin countries. Some countries, they accept parents that are dependent due to age or health issues. So for example, Germany and Latvia and the Czech Republic, or parents to guarantee the right to life, dependent parents, and adult children in some situations. So children with disabilities or health problems, in exceptional cases, not over 26 years like the Czech Republic, or not over 23 like Ireland. And even in those situations where extended family can be accepted, this depends a lot on the discretionarity of the state, and especially of the organizations and institutions and national institutions involved in the family reunification, and later in the discretionarity of the diplomats who will be granting the visa abroad. There are some important, some countries that have been accepting same-sex couples, marriage, or in a stable relationship. But the problem with this is how it's difficult to prove the same-sex relationships, because in many countries, people are persecuted for having same-sex relationships. So they cannot prove they have a relationship. And then it's really, really hard to get family reunification in those cases. Some countries, they do same-sex couples. So for example, Slovakia, Malta, and Poland. Some countries accept non-married couples. Some other countries accept other dependent family members under special circumstances. Some countries accept national or adopted children as with the same rights. Some other countries, they do not accept adopted children. And most of the countries, they do not accept polygamous marriage or marriages by proxy. So they need to have a marriage in the presence of both spouses. And those information is based on data of the European Migration Network from 2017. So in general, the definition of family is really political in those countries, in European countries, and they really depend on the political way that those countries see families, and the discretionarity of the national institutions and the diplomats granting the visa. Another huge problem involving family reunification in general is accessing to visa, especially when we have left behind children. Even though almost all countries in European Union and the European Union have adopted guidelines and procedures to determine the best interests of children involved in family reunification procedures. There are some reports, so for example, some reports from the UK saying that children have a hard time to access the embassy. So some families, they have to engage in dangerous journeys to arrive in an embassy and to apply for the visa. And some children, since they are children, the visas, they don't have child-friendly procedures for children to apply for visas, which make it really, really harder for children to actually get the visa and arrive in the country. Besides the other problems that we already discussed. So this in general is the situation in Europe. So by one hand, we have a guarantee to the right to the family reunification for refugees, but by the other hand, is getting harder to access this right in practice. The other problem is that there are different rules for refugees and forced displaced people that have different status. So for example, subsidiary protection or humanitarian protection. Subsidiary protection is protection given to people that are not recognized as refugees, but they cannot return to their countries because their life would be in danger or of torture. So the countries, they give subsidiary protection for those people. There are some critics that say that today countries are less willing to grant refugee status to people when they grant subsidiary protection or humanitarian protection. Some countries call it humanitarian protection. That is because those subsidiary protection and humanitarian protection, they have a deadline, they are subject to permanent review, while the asylum is based in the international treaty that states have to respect. So in general, there is a decrease in the number of refugees status granting in European countries. So for example, in Switzerland, even though is not part of the European Union, they accept the Schengen agreements considering tourists and Schengen visas, and they accept the Dublin agreements considering asylum applications. They have two types of resident permits. So if a person applies for asylum and they are recognized as a refugee, she's recognized as a refugee, she will receive a B permit. If she applies for asylum, but the government does not understand that they qualify for asylum, that they have a individualized, well-funded fear of persecution due to their race, religion, nationality, membership of a particular social group, they will be granted, but that they cannot return to their countries because they will suffer a human rights violation or torture, or their lives would be at risk. They will receive an F visa, which is kind of subsidiary protection visa, temporary visa, that they have a deadline. And those people with the F visas, they have a really hard time to achieve family reunification. So in many countries, they don't consider it the same rules for holders of subsidiary protection for family reunification as refugees. So for example, Germany used to, but there were some decisions from the German government to suspend family reunification for holders of subsidiary protection. So they have more exigencies to apply for family reunification than refugees. And especially some countries, they do not exempt the holders of subsidiary protection of material requirements, or they do not guarantee the right to family reunification at all, or they have to wait a minimum time. So there is a case currently under analysis of the Grand Chamber of the European Court of Human Rights. There is the case MA versus Denmark. It's about a Syrian family, a Syrian man actually, who had subsidiary protection in Denmark, and he applied for family reunification to his wife. And his request was denied because he did not meet the requirements to apply for family reunification. So this guy, he appealed, and after all the high levels, high instances, high courts of Denmark denying the family reunification, he entered with an application in the European Court of Human Rights saying that the Denmark rules, considering people that have subsidiary protection right to family reunification, they violate the right to life, Article 8 of European Court of Human Rights, and they discriminate against people who have refugee status and who have subsidiary protection. And this will be a really important case because, for example, many Syrians in Europe, they don't have the refugee status, they receive subsidiary protection or other humanitarian protection mechanisms. So they have a hard time to access family reunification as well. So let's talk a little bit about family reunification in Latin America. So first of all, Latin America has their own development considering asylum. So in 1984, the Latin American countries, they adopted the Declaration of Cartagena. And one of the important things that the Declaration of Cartagena did was, hey, for us, asylum has an expanded definition. So we will also recognize as refugees people that are fleeing situations of grave and generalized violation of human rights. And many countries in Latin America, most countries in Latin America who adopted national legislation on asylum, they have expanded definitions of refugees. So for example, Syrians in Brazil, all Syrians in Brazil, they are recognized as refugees. And right now, Venezuelans, they are also recognized as refugees because the Brazilian government recognized that there was a situation of generalized violation of human rights in Venezuela. So in that sense, you have more people being recognized, in theory, that can be recognized as refugees in Latin America than in other regions, because the countries, they actually applied this expanded definition. And since the 84, the countries in Latin America, they meet each 10 years to rediscuss asylum in the region. So what will be the situation of asylum? What will be the challenges? And the topic of family reunification, they appears in 3 of those documents. So recognizing that the reunification of families is a fundamental principle to refugees, and they should receive a humanitarian treatment in 84. And then in 2004, they recognized the family unit as a fundamental human rights for refugees, and they recommend the adoption of mechanisms to guarantee it. And in 2014, the Brazil's declaration, they recognize the importance of considering age, gender, and diversity in refugee status determination procedures, and also in application for family reunification as appropriate. The second thing that Latin America is interested in is that we have an expanded definition of family. So for example, in 2014, the Inter-American Court of Human Rights, they received a request of an advisory opinion from Brazil, Argentina, Uruguay, and Paraguay on the situation of children in need of protection or involved in situation of international migration. And then you have this wonderful advisory opinion of the court on the rights of children and the duties of the state with those children. Although this advisory opinion is not ruling, is not mandatory, it gives a lot of information on how the court will decide in case one of those cases end up in the court. And the interesting thing is that the definition of family that the Inter-American Court is advocating is way bigger. So they say that in cases involving children, the definition of family should not be just the couple and their children, but because other relatives may also be entitled to the right to family life, such as uncles, aunts, cousins, grandparents. And they go beyond that, calling for something called as emotional dependency, when they say, furthermore, in the migratory context, family ties may have been established between individuals who are not necessarily family members in a legal sense. So it says that maybe the migration created a situation of emotional dependence that friends can be considered family. And that's a very important extended definition of family in the context of migration that we have right now in the Latin American context. However, most of the countries in Latin America, they do not accept this emotional dependence, but there is, in general, a recognition of the right to family reunification and family unit as a principle of the asylum law or migration law in countries like Mexico, Peru, Argentina, Venezuela, Uruguay, Paraguay, Ecuador, Chile, Bolivia, and Brazil. And those countries, when they have this asylum national legislation, they have extended definitions of families, including not just official marriage and not just biological children. And some of those definitions, they are restricted by kinship or economic dependence. The only exception is Colombia, which has just a nuclear family definition. So for example, Brazil has a very broad definition of family, so we include descendants and ascendants without any need to prove an economic dependence relationship. So grandparents, great-grandparents, children, great-children, adult children, minor children, it doesn't matter. And other family members, since there is a relationship of economic dependence between the refugee and the family members. So cousins, father-in-law, mother-in-law, brothers, sisters, aunts, nephews, nieces. Since there is this economic dependence relationship, no problem. The problem is that there is no definition of what economic dependence means, and more how you prove economic dependence. And most of the countries, they have few or no consideration for emotional dependence. So they are not really accepting the advisory opinion of the Inter-American Court. And many of those countries, they don't have clear procedures to apply for family reunification. So there is no clear mechanism in the legislation on how to apply. And once the procedure is not granted or denied for any reasons, there is no appellation mechanisms or review mechanisms clear. This also happens in Brazil, which is a major problem in the region. So in Brazil, that is my case, we have some challenges, the best practice. So Brazil adopts an expanded definition of family, and they have a clear procedure of how to apply for the family reunification visa. So for example, Venezuelans, they don't need to apply for family reunification visas, but Syrians, Congolese, most African countries, the African nationals, they have to apply for family reunification visas for their families. And one of the problems with the procedure is that there is no clear deadline. So some procedures can be really fast, some others can take longer. And there is no clear definition of economic dependence. So it changes a lot on how the diplomat abroad understands economic dependence and how the refugee should prove it, or how the National Committee for Refugees understands economic dependence. So it changes a lot because the president and the coordinator of the National Committee of Refugees, they are political appointments. So if you have a National Committee for Refugees that is more open to asylum procedures or more humanitarian, you can have a more relaxed definition of economic dependence. But if you have a more authoritarian CONADI, then things get harder. And there are a lot of discretionary decisions, especially from the Ministry of Foreign Affairs, the MRA, considering the visas. So even in cases where the visas were approved by the National Committee of Refugees, once the applicant, for example, the mother of the refugee arrived in the Brazilian embassy abroad to apply for the visas, the diplomats, they said, oh, but this is not a real relationship of mother and son. They have like fake documents. And then the visas, they were denied without further information, without no clear appeal procedures, no review procedures, and no right for the refugee to prove that the definition of that diplomat was mistaken. Refugees, they pay for all costs of family reunifications. So the visas, the passports, the tickets, everything. And it's a very consuming procedure, considering time. There are a lot of delays. And the refugees, they can just apply for family reunification after they are recognized as refugees. But the refugee status determination procedure in Brazil is longer than 2 years now. So for 2 years, as asylum seekers, they cannot apply for family reunification. They are separated from the families. There are a lot of difficult to access proper data on family reunification visas requests in Brazil, and even for refugees and the civil society organizations supporting them to access information about the procedure. So what is the procedure? Why the visa was denied? And again, no clear appeal procedures, no revision procedures. So the refugee, they don't know how to do the law. There is no clear law, no clear normative to do this review. But at the same time, we have Brazil has some best practice. So the visa procedure is facilitated. So it's an administrative procedure. In theory, the refugee can apply without help of lawyers. There is no DNA tests, no waiting times once the refugee is recognized as a refugee, no integration procedure, so the refugee has not to prove the government that they are working or they have a house or that the person that they are inviting will learn Portuguese. And they have the support of civil society organizations in Brazil that active participate in CONARI, and especially the expanded definition of family, which opens a lot of possibilities. So many refugee women, especially that brought their sisters or mothers to stay with their children so they could go back to work and help with these activities of care and taking care of the house. So this is a good best practice that we have not only in Brazil, but in many Latin American countries. So conclusions. In general, we see in the law, in the normative, in the regulation, in Europe and in Latin America, a recognition of the right to family reunification for refugees, which is positive because we had not this consensus in 1951 when the convention relating to refugee status was approved. But at the same time, we see in practice this right being harder in Europe and in Latin America. But Europe can learn from Latin America and Latin America can learn from Europe. So what can Europe learn from Latin America? Actually granting facilitated visa procedures. So rethinking about DNA tests, integration requirements, material exigencies, maximum deadlines and waiting limits, especially in the case of holders of subsidiary protection, expanding definition of families to allow different cultural backgrounds and social conceptions of family, avoiding this division between asylum and humanitarian protection or subsidiary protection, granting the same rights for both groups since they are both forced migrants. Avoiding any type of family reunification quotas for refugees. So some countries like the US, they adopt some quotas based on nationality, and refugees, they enter in the same quota than other nationals. What can Latin America learn from Europe? So adopting clear procedures and deadlines, guaranteeing the right to appeal and the revision, guaranteeing the due process and due procedures in family reunification in all times. So from the application until the last possible appeal. Also adopting guidelines on the best interest of the child and urgent cases, because there are no prioritizing mechanism in countries in Latin America, like Brazil. In theory, there is, but not in practice. And also adopting some funding schemes. So some countries in Europe and some organizations, they have partnership with some organizations to fund sometimes the tickets or the visas, and then the refugee can pay back to the state in installments easily, granting expedited family reunification in those cases. So I think that is the general idea I would like to discuss with you today. And thank you so much for your time and attention. And I think that's it. Thank you.
Thank you very much for that, Patricia. That was really very informative and so much information in there, which I think we can all really learn from. What I found really interesting was the different definitions of family, reunification, what constitutes as family reunification, children, and so on, even the definition of family and how that can really differ from country to country. And what I thought was particularly interesting was how wide these definitions are in Latin America, which at face value is really positive. But then, you know, that's obviously in stark contrast to the narrow definitions and legislation that you highlighted in the European continent. But what then seems concerning is that in Latin America, this almost, perhaps correct me if I'm wrong, Patricia, but it almost seems to be a facade behind which there is a very dark reality, and a reality where people are not reunited due to things like bureaucracy, procedure, which when you look at the definitions and the legislation, it seems that actually it should be going the other way and families should be reunited. That was something which I found very poignant from what you were saying.
Yes, yes, especially my research on Latin America, more specifically in Brazil. If we take just the legislation, is really positive, but the problems are in the implementation, and this implementation is still really open to discretionarity and political will of governments. So, for example, in Brazil, we probably had no problems of family reunification until 2016. Things started getting really hard, especially for Congolese refugees after 2017, especially because of political lobby from diplomats and the Brazilian ambassador in the Brazilian embassy in Kinshasa in the Democratic Republic of Congo, saying that the refugees were using family reunification were misusing the right to family reunification actually to bring people that were not family in our definition of family, and then making the entire procedure harder for all refugees. So although we have good legislation, I think in family reunification, better legislation, of course, than in Europe and most developed countries, we still have a long way to go. Some countries, they don't have a clear procedure for family reunification in Latin America, not because they don't want to, but because they lack capacity to develop those clear procedures. So that's why I think is really useful, this dialogue, this comparative study between experiences in Europe and Latin America.
Definitely, I think that's really poignant. We've got a question that's just come in asking, what are your thoughts on the extent to which problematic aspects of family reunification have had an impact on increasing the risk of trafficking amongst those seeking asylum?
Yes, I have a personal story from Brazil during my fieldwork. So there was a case of a refugee, a male refugee. He was applying for family reunification for his two underage children that were back in Congo. He applied for the visa, he delivered the documents, and the visa was denied. And this guy and the organizations that were supporting them in Brazil, they never knew why the visa was denied. So the kids, they were alone in Congo in a very risky situation, and the guy in Brazil, the refugee in Brazil, was desperate. So he paid somebody to bring the kids to Brazil using, so he bought a ticket for the kids from Kinshasa to Ecuador. And from there in Ecuador, there are some groups, some smuggling groups that they cross the border with Peru and then with Brazil by bus. So they are very dangerous journeys. A lot of Haitians, they used to use this way to arrive in Brazil before the creation of humanitarian visas for Haitians. And they're very dangerous journeys because the driveway is really complicated, and you have some groups, some criminal groups who rob and abuse the migrants involved in this journey. And also the police sometimes bribes migrants in this journey. So the guy was desperate in Brazil, and he sent this. In the middle of the journey, when they were already in South America, the guy lost contact with the kids and the smuggler. So the refugee, he was desperate. He just went to Ecuador. After, I don't know, 1 month, he was missing, the kids were missing, but then the kids arrived in Brazil. We don't know how they managed. They arrived in Brazil. They entered in contact with the authorities, and then the authorities, they traced their father. But the father was missing. So when the kids actually arrived, the father was missing and they were unaccompanied in Brazil. the father, they never heard of the father again. We don't know what happened to the father, and the kids, they were in Brazil alone now. So this is the type of situation that could be avoided if the Brazilian government had just granted the visa. If the procedure was better, if there was a review mechanism, if there was an appeal mechanism, if this refugee had information on why the visa was denied, to say maybe there was a misunderstanding, or I can give you further evidence or other types of evidence to say, hey, those are actually my children. And this is just a case. So my point is that family reunification visas, they are necessary to keep families united, and especially if we want to integrate refugees. No refugee will be integrated if he or she is worried if their children are left behind, if they are eating or not, if they are alive or not. And every time we make family reunification visas harder, we are just giving a lot of money to human trafficking organizations, criminal transnational organizations, because people, they are at risk, they have to leave. So I think that is another thing that we don't study a lot, global south countries as host countries or asylum countries. And we should also be studying this and how the policies that these countries have been adopting can really impact the life of people as well.
Yeah, definitely. And on that sort of topic, or in relation to that particular case that you've just given, what's your perspective of what best practice would be in terms of helping unaccompanied minors in this process? Because obviously there are some countries that you highlighted. I think the UK is one of them, where unaccompanied minors aren't eligible to family reunification. So what would you say would be the best kind of way of approaching that particular type of case?
I think granting them the right to family reunification without discrimination, and then conducting assessments of to determine and determination of the best interests of the child of children involved in the procedure. Because sometimes, even if because an adult refugee can be applying for the family reunification visas for their left behind children. So those children, they are not in the country, but they are children, and they should have their best interested accessed in the family reunification procedure. Or unaccompanied children, they should have their best interested determined, and other children involved in the procedure, they should have. So I think adopting clear guidelines on how to access and to determine the best interests of all children involved in the family reunification procedures, they are important. And especially adopting child-friendly procedures to apply for visas in cases, especially in cases of unaccompanied children or in children left behind.
And what sort of children-friendly procedures do you think would be applicable?
I think maybe having a facilitator, having facilitated forms. For example, if we are thinking of children left behind, who would have to apply in the embassies? The embassies can be really, really scary environments, really, not welcoming environments. So first, training the diplomats on best interests. They should also have training on how to determine the best interests of children applying for visas, which they don't receive, at least in Brazil. And then having like a focal point, like a psychiatrist or a child expert that can be consulted in cases where children will be applying for visas alone, which are not that much in Brazil, for example, in cases involve Brazil. So having this person that can act as a focal point maybe, and making the forms way easier, or I don't know, allowing the adults in Brazil to fulfill these forms for the children, and guaranteeing or having or putting this focal point, this child expert or this child psychiatrist, psychologist, there is the focal point in the embassy or in the zone, in contact with the refugee in Brazil, to the adult refugee in Brazil, to have this, to supporting the procedure, but training the diplomats not only in on the best interests of children and children's rights, but also in asylum topics. One problem that we have in Brazil is that the diplomats, they see families of refugees applying for visas as any other people applying for visas. And that's the problem. So they see them as possibly bogus refugees or suspected or illegal migrants, and all these labels that diplomats that are not really trained to deal with people in need of international protection, they use.
Yeah, that completely makes sense. And actually picking up on something which you said, you spoke about sort of mediators. This leads quite nicely onto a question that's been submitted. This question says, I heard that in some countries, interviews are conducted to establish family links. Do you think cultural mediators should be present during these interviews to better understand the cultural concept the refugee has of family?
Absolutely, absolutely. I can say about my research in Brazil, and one of the things that we realized is that in Brazil, the Brazilian bureaucracy, so the National Committee of Refugees, the Minister of Foreign Affairs in Brazil, they trust a lot in the diplomats abroad. So they trust that those diplomats, they will know more about this culture, they will know more about what does it mean an economic dependence in that country, because they know like what is the minimum salary, how much things cost there. So they can say if a person is sending $10, maybe she's sending $10, which is nothing in Brazil or here in Zurich, but in, I don't know, in Somalia, $10 can be a lot and can really provide. But actually they don't. So for example, many Brazilian diplomats, they live in a bubble. So it's not that they are out there having contact with the organization. So some Brazilian diplomats, they have a very clear definition against migration in general, and they will be used. So having this knowledge of culture, having this cultural mediation, especially in the embassies, can really, really help. So for example, one of the things that I realized, and it took me a lot to realize the entire PhD, was the definitions of family for the Congolese, for example. So a lot of the Congolese, they would call brothers everybody, even friends. And a lot of the Congolese in Brazil, they were raised by people that were not their parents. So they were raised by uncles, by aunts, or by grandparents. In Brazil, when you are raised by those family members, you will continue calling them uncle, aunt, and their children, nieces and cousins, whatever. But for the Congolese, no, they will start calling that person who raised them of father and mother. And by the time they would put this information in the form, they would say, oh, she's my mom. Although for us, for our culture, that woman that raised him is not the mother, is the aunt. But he called her the entire life of aunt, and the children that would be cousins of brothers and sisters. And when they apply for family reunification, they will say, hey, this is my sister, or this is my brother, or my mom. And by the time they would give the birth certificates and the diplomats would see the discrepancies, wait, it's not the mother, it's another person. The diplomats, they would deny it without even questioning. So for example, in my PhD, I have a case of a refugee that I interviewed about his family reunification procedure with his mom. Then I analyzed the diplomatic correspondence between the diplomats in Kinshasa, the Brazilian diplomats, and the Minister of Foreign Affairs in Brazil about his case, about his analysis. So we can, and when I was interviewing him, he had no idea I had this information about his case. So he was explained to me that he was raised by his uncle, he called father, and then this uncle was involved in politics and he was killed. And because of that, they persecuted the immediate family of the cousin of the uncle. But then his father and his mother, they were alive. His mother, she just had boys, but his father, he had other relationships with other women. So he also had daughters. So the refugee in Brazil, he had brothers and sisters. The main problem, oh, I think this is, the main problem with this case is that, so he applied for the family reunification for his mother. And before that, he had already applied for the family reunification of a sister who was in Brazil. So that time he was applying for the mother. And in Brazil, the asylum procedure is confidential. So the information that the refugee gives why he's in Brazil is confidential. So no one in Brazil can ask why you are here, what is your case based, and no other authority can ask that. But in his case, the ambassador in Brazil, he had access to his files. So he knew the persecution he was facing, so for example. So when the ambassador went to interview his mother, he asked her, tell me about your family, about your husband. And she told, well, my husband, he's a farmer. We live together, this type of stuff. And then the ambassador asked, how many children do you have? And she said, I just have, I don't know, 3 sons, something like this. But the guy said, you have no daughter? And she said, I have no daughter. So for this ambassador, this woman was lying, or the refugee was lying, because the refugee had brought a sister, and the refugee told in the asylum procedure that his father was killed, but the woman told that her husband was alive. That was a clear misunderstanding, that the ambassador could have sent a message, hey, could you please clarify this information? And then the refugee was just like, hey, I was raised by my uncle, I called him dad, but my real dad is alive. My mom, she just had sons, but my sister that I brought is just my half sister, but we call sister because she's just the daughter of my father. But then the guy just used this misunderstanding, this cultural thing, to deny the visa without further explanation. So that's really, really important.
That's really quite a shocking story of how, I mean, one person, a diplomat in this situation, can, you know, make a decision which obviously affects multiple lives, which is dictated by, it could be ignorance, personal opinion. So it sounds as though what we really need in, for example, in Brazil, where it is often dependent on diplomats, is to have, as you noted, sort of these mediators, these experts who can note on the customs in those particular countries and say, this is the language used, this is what X means, Y means, and so on, so that we can hopefully dispel that sort of, those sort of decisions being made, which obviously are completely contrary to what really should have been granted. I'm conscious of time, and unfortunately we have 2 minutes left, so I think I will have to sadly wrap up this webinar. But I mean, I'm sure that we could continue this conversation on, and I know that, I mean, Patricia and I have spoken for, I think, probably 2 hours once about this particular topic, and there's so much more work that needs to be done on it. And really, I think hats off to you, Patricia, for the work that you have been doing, because I think what I really want to highlight to the viewers is that your research has been very eye-opening in terms of the way that the system operates, particularly in Brazil, in terms of bureaucracy, which at face value, I didn't know that. Looking at the legislation, it seems quite clear cut, but obviously research like yours really highlights the reality of the situation. So really a massive thank you for enlightening us today with your research and with your knowledge, which is a fountain of knowledge, I think we can all agree. And just a note to everyone watching that this YouTube live stream is going to be saved, so you can watch it again and again. If you really loved it that much, I know that you probably did. So you can watch it at your leisure. share with people. Also, just kind of share with as many people as possible, because work like Patricia's is really important, and we want to be able to support that as much as we can. So I will leave you all now to enjoy your evening, and a huge thank you to you, Patricia, for taking the time to present this wonderful topic to us. Thank you very much.
Thank you. It was my pleasure.
Thank you.